And Tejus, I'm sure you're sitting in Singapore right now.
As of today, yes, I'm in Singapore.
With you, we can never know for sure. From DIS, which is the German institution, we have Paulus from the DIS. And Paulus, could you please tell us where are you based today?
I'm based in our main office in Bonn, Germany, the former capital city of Germany.
Okay. So, and we also have another panelist from the LCIA, Eliana, who we are waiting for. She is from London. I think we can start, and hopefully by the time the first question finishes with the three of you, she would have joined by then. So the mandate for today from LCIA and the India ADR week is to keep the conversation informal today. So I hope we can keep it that and a little interactive. And with that, my first question for the day is, and I'm going to leave it to you guys to answer your favorites in here. Which is the one distinguishing feature of your respective institution or institutional rules, which plays a key role in the dispute resolution process, or that you think brings the parties to you? Oh, there we have Eliana. So Eliana, why don't you go first with that question?
Yes.
We introduced you while you were still logging on, don't worry.
So I'm the registrar of the LCIA, and I've been registrar for the past 4 years. I was a deputy registrar just before. So moving on to the question, I think the question that was addressed to me, or to the LCIA in particular, is the interpretation of Article 6.1 and 6.2. The LCIA...
Eliana,
yeah.
Sorry, the first question was, what is the one distinguishing feature of your institution or institutional rules that you think is key to the dispute resolution process between the parties, or the one factor that brings the parties to LCIA according to you?
Of course, yes.
Come
So
to the
sorry
other
about
one
that.
later. No?
So I think the distinguishing factor of the LCA is probably the fact that our unique selling point is the fact that we are working on an hourly basis, as opposed to the majority of the other institutions working on ad valorem cases. And the hourly rate system applies to the staff of the LCA, the work of the LCA, as well as the tribunal and the arbitral tribunal appointed on the case. And I think the cost and duration analysis that we've published over the years show that we are a very competitive institution in that respect in terms of fees. So, and it's really, it gives discipline to the parties to make sure that they're only raising or dealing with the main issue, so as to avoid unnecessary work by the tribunal, and you end up with a tribunal satisfied with their way of remuneration, because in an hourly rate system, they are paid for the actual work done, while in an ad valorem system, it doesn't really matter how much work you're doing. You know already the set fees you'll be paid.
Okay, that's interesting to know that it's on an... I did not actually know that you all work on this hourly basis system, and there's a cost analysis that you all have published. I'm definitely going to have a look at that. Elisabeth, why don't you go next on the same question, please?
Sure, thank you so much. So I thought about finding one particular article that I might address here, but actually it occurred to me that it's much more a special characteristic of our rules in general that makes us stand out, I guess. And the term is flexibility. So in my experience at VIAC throughout the years, it's always been the aim of the VIAC rules makers to stay really flexible with our rules, always, of course, bearing in mind also predictability. But this means that the VIAC rules, of course, cover all the scenarios in the course of arbitral proceedings, and you can find answers somewhere in our rules, but they will not be all addressed explicitly. So we have many provisions that are kind of open-ended. For example, there are no specific restrictions on the party's choice of arbitrators. We don't have terms of reference, case management conference, all those things in our rule, or a preliminary assessment is not directly addressed in our rules, for example. But we do believe that under the discretion of the arbitral tribunal, together with the parties, you can find solutions for all of this under our rules. And this, I think this aim for flexibility has to do with the market that we have, with our historic positioning in the market. Usually the seat in arbitrations, or a very high percentage, is Vienna. And many times one of the parties stems from a CEE country. And this is really what the users expect from us, so that we really decide on a case-by-case basis and are really hands-on in a particular case.
So what I'm hearing is really that party autonomy kind of stays a lot more in the VIAC set of rules, because things are more flexible in the way you interpret them case-by-case basis.
It's party autonomy on one hand, and discretion, recent discretion by the arbitrators and the institution always, and we're always a lot in exchange with the parties. We're rather, we're not a huge institution, we're very hands-on, so there is a lot of communication among the parties, the arbitrators, and the institution.
Got that. Tejus, can I ask you the same question, please?
Sure. Greetings, everyone. So I think for the ICC, if you were to look at the rules, I would say Article 34, which is the scrutiny of awards by the institution. Now, scrutiny by the ICC is, and every institution has its own way of reviewing awards. Some have a light touch, some have more of scrutiny, and the ICC is a 3-level scrutiny process, where it's not just the Secretariat, which is the first level of review by the council in charge, second level by the management of the Secretariat, and then the third level, which is the ICC court. And I say ICC court, of course, because it's about 190 members from about 120 countries, including from India, where we have Sanjeev Kapoor as one of the vice presidents, Amar Gupta and Payal Chatterjee as the 2 court members, who will review awards and who will ensure that each and every award is approved by the ICC before it can be notified by the arbitral tribunal. And I think that this is a process that really works, because if you look at the numbers each year that the ICC notifies in terms of awards, and I can look at 2023, where we notified about 520 awards, 512 awards had comments from the court, from the ICC. Only 8 awards did not have any comments, and there were 42 awards that were not approved at all. So to put this into perspective, if there was no scrutiny and there were those 42 cases which did not go through the process of scrutiny, I think that would have posed challenges for enforcement. So we really see this process as something that works and something that is
so we know that scrutiny is a big strength of the ICC. Do you think that the scrutiny looks at at least the due process part of it, you all definitely look at? Is there anything else that you all consider apart from the due process, while you're scrutinizing, since 3-level scrutiny you're saying?
Yeah, so the rules, of course, there's a public document, which is the ICC award checklist, but the rules provide for that the ICC can make comments as to form, but also draw the tribunal's attention to matters of substance. So what this essentially means is that if the ICC is aware of requirements of a particular seat, the ICC will notify the tribunal that these are the requirements of the seat and this is something that you've missed. Many times we would perhaps see that the tribunal has just, the dispositive part is not something which has been properly framed, and we would draw the tribunal's attention to that. So again, many elements of scrutiny, and it's fascinating to see that even the good tribunals and the good arbitrators can sometimes get it wrong or might miss it.
Well, Paulus, can I ask you to give your comments now, please?
Thank you very much, and thank you very much for having us in this great forum. we are coming from a German background, from a German law, and we absolutely believe in early termination. We understand a dispute to be a disturbance for the parties, for the natural parties, which are mostly companies that do run something different than a dispute. And in that sense, we do believe that as early as a dispute can be terminated, this saves not only costs, but also valuable time. And I can tell you from our stats that from all our arbitrations that have started with our rules beginning effective 1st March 2018, 65% have been terminated early. Now, of course, this number does not represent all numbers that have been amicably settled. But however, you see that the vast majority of our cases are terminated early, and differently than Eliana just introduced at the beginning, as DIS is following a very strict ad valorem system, the DIS rules also provide for a fixing of arbitrators' fees based on the work done by the arbitrators, which means a reduced fee regarding arbitrators by our governing body, the DIS Arbitration Council, consisting of 18 very well-known international arbitrators.
Okay, that's interesting to know that. I mean, German precision we all know about. So I'm glad to hear about this this ethos that you all believe in of early termination. Eliana, if I can come back to you now, the LCIA rules provide that a sole or presiding arbitrator should not have the same nationality as any of the parties. But if the party is a legal person, then the nationality is determined by its controlling shareholders, and there has to be disclosures around that. How does this analysis practically take place at your end? Do you have any guidelines or do you have any experience around this, and could you explain the process to us?
Yes. So actually the process really starts with gathering the information from the very beginning of the case, because as soon as as soon as the request is filed, one of the requirements that are asked in Article 1 is for the claimant to indicate all the relevant information relating to the parties. And by that we also mean the incorporation of the company, as well as the seat of effective management. So effectively what happened is that as soon as we acknowledge receipt of the request for arbitration, in the first letter to the parties, we inform the parties that based on information we have, we understand that the company is registered in this jurisdiction, and it has its seat of effective management in this other jurisdiction. And if either of these issues are unclear, then we will follow up with a question. And similarly, in relation to the shareholders, in essence, we tell the parties, these are the nationality we think are relevant on the basis of Article 6. And obviously our assessment is done on the basis of the information that the parties are giving us. We don't do any audit or any investigation because the investigation we would do would be not sophisticated enough, would be through maybe a Google search or even a registry. And they may not be completely relevant. So the issue really is when the parties have disputes around really what are the shareholders, then I think that that's the moment in which the court starts to make a more in-depth analysis of the provision you mentioned about the majority shareholder. And we gather the information from the parties, asking the question of why one party believes that the relevant shareholders are these, and why the other parties believes that the others. But in truth, I think we try to really stick with what is the wording of the article, and we try to stick with the controlling shareholders. And by controlling, we generally mean the majority shareholders. We often have, for example, allegation that because a company has a director of a certain nationality, then that nationality needs to be taken into account. And obviously, the nationality of the director is not relevant, even when it comes with the allegation from one of the parties that it's controlling the company. So this is really the process, is information gathering from the parties, and then we give, in a way, the decision to the parties if there is a dispute. But I think in my experience, really, we only have a handful of cases a year where the parties disagree as to who are the controlling shareholders or what are the interests of a company.
No, this provision really caught my. It's a very interesting clause, and apart from the fact of the neutrality of the arbitrator, the reason it caught my eye was also because in one of the cases that we did a while back, this kind of a disclosure wasn't there. And if there is a disclosure like this, even if it's not sophisticated, if it's there, it helps in enforcement of some sort, where you try to add the controlling shareholder in some way if the company itself can't be pinned down. So it's an interesting provision to have in an institution in that sense. Elisabeth, the VIAC rules were revised in 2021, and you all got on the very hotly new debated topic of third-party funding. And what I wanted to ask you was that there's disclosure requirements regarding third-party funding under the VIAC rules. So what are the disclosures that the VIAC is really looking at practically in spirit and in letter? And have you seen the tribunal order costs for the third-party funders in the last few years that you'll have added this provision?
Thank you for the question. So to put it a little bit into perspective, the 2021 rules revision at the VIAC was actually triggered because we introduced investment rules, a new set of investment rules. And we basically took that occasion to tackle some issues that we saw coming. And one of those, of course, was third-party funding, where obviously we observed this trend throughout the past years that it has become increasingly popular. From a practical perspective, I want to give you our statistics as well, because we actually do not see a whole lot of cases where third-party funding was disclosed. So according to our statistics of 2023, the last year, the percentage of new cases where third-party funding was disclosed was 4%. So in numbers, that was like 3 cases or something. So the answers I can give you are first, based on our rules, and then with that small practical background. And bearing that in mind, I would like to address your first question regarding the disclosures. So really, in the rules revision, our main aim was to address the potential issue of conflict of interests with third-party funders. And to that end, we introduced 2 rules. One rule is a definition rule, where we used quite a broad definition of third-party funding. So this is the basis we need in our rules. And then the second rule that we really introduced that really tackles the issue is the disclosure provision. And this one says that a party shall disclose the existence, and this goes directly to your question, what should the parties disclose? It's the existence of a third-party funding and the identity of the funder. So it's those 2 things that parties have to disclose. And if a party discloses this, we will then inform the arbitrators and forward this information to the arbitrators.
So, I mean, in India, it's still at a very, very nascent stage. I don't think we have even a 4% figure here. The reason I asked this, I have this follow-up question. You said that you wanted the disclosure for conflict purposes. Where do you perceive the conflict? Is it with the nationality of the funder, with the arbitrator being neutral, or with what kind of a conflict are you perceiving in the third-party funding?
No, it's really mainly to give the arbitrator the chance to include the third-party funder in its own disclosure, and there's potentially more. Those things are the ones that have to be disclosed, but there's potentially more, because arbitrators also in commercial arbitrations shall have the possibility and the right, under the normal conduct of the arbitration discretion, kind of, to also ask for more if they think that there is a reason. So it might be under their discretion, they might also ask for the content of an agreement. And what does that mean, from the practical experience that I've had? How does it play out in practice? Claimants were good in disclosing the things they had to disclose under the rules. I also saw a claimant that voluntarily disclosed the full agreement. And I haven't seen requests from the arbitrators. They only addressed third-party funding if any issues arose, if respondent, objected in some way. So that, in order to answer your question, also in practice, this has really served for the purpose to provide a full basis for arbitrators to make their own disclosures.
Thank you. That's very interesting to know how it works. I was very intrigued when I read this provision. Tejus, I have read this provision in the ICC many times, but I still don't have an answer to it. So the ICC provision, I think the rules 12.9 provides ICC the power to appoint members of the tribunal, notwithstanding any agreement between the parties in exceptional circumstances. Arbitration works on party autonomy. So what kind of exceptional circumstances could there possibly be, or that you all think are, that would, invoke this particular rule, 12.9?
Absolutely, Nandini. And I think today you will have your answer. Arbitration works on party autonomy. Arbitration also works on safeguarding the entire process of arbitration. And I think that was the idea behind this specific provision. So when we normally apply this provision, there would be instances of, for example, where the arbitration agreement itself provides for the method of constitution of the tribunal, which might be prejudicial. So, for example, one party nominating the entire tribunal, or one party itself appointing the sole arbitrator. In such a case, the ICC would step in and perhaps appoint the tribunal or the sole arbitrator. Another instance that I can think of is, for example, when there's a non-participating respondent and there are multiple respondents and we're not sure about whether, and they have to jointly propose an arbitrator, and we're not sure about whether the non-participating respondents' interests are aligned with the other parties, and the ICC would then perhaps nominate. Or the third scenario, when, for example, there is a joinder of an additional party and that party refuses to nominate either with the claimant or the respondent, and the ICC would step in to then nominate and appoint the arbitration tribunal, because you would then deem that the non-participating respondent has not participated in the constitution of the tribunal. So these are some of the circumstances where the ICC would step in.
Okay, so this is largely a multi-contract or a multi-party situation where you're looking at, for the betterment of the entire process for the ICC to step in.
Absolutely, and there are several of those at the ICC. So
okay, that makes sense, because I couldn't figure out that what could it be. Thank you for that, Paulus. There's this provision in DIS that empowers the tribunal to provide the parties with a preliminary non-binding assessment of factual or legal issues in the arbitration after taking consent of the parties. And this kind of, to me, sort of circles back to your point of, believing in early termination, right? So my question to you is that, given that you have this kind of a provision, how often are tribunal proceedings undertaken after such a strong, sort of a finding, such a strong clause that some things will help to be non-binding, but while giving evidence or while giving submissions, you might have to rely on those points. So how does it really work? And do you see parties settling more often because of this kind of a provision, or the arbitrations ending early because of these kind of provisions?
Thank you very much for the question. I'm very impressed that you go in the very gist of the unique points of the DIS arbitration rules. But maybe let me first of all clarify the meaning of preliminary in that sense. It is not in sense of the phase of the arbitration, but preliminary in content. Article 26 DIS arbitration rules makes that clear, because amicable settlement is to be tried at every stage of the arbitration. And we do also see that in the stats. But very important is that such a preliminary non-binding assessment is only provided that all parties consent thereto. That means as soon as there is one party saying no, that means a no. There won't be any preliminary assessment. Annex 3 that you referred to is one of the whole list of measures for increasing procedural efficiency that we do believe at DIS is a very important key. But let me also provide you here with some stats, and I just go back and follow up with the number of over 60% of early termination. From these numbers, 245 cases needed to be decided by the DIS Arbitration Council, fixing arbitrators' fees because of early termination. And this number represents about 42% of all early terminations, and which also means that the parties have agreed to terminate their arbitration early. But from these numbers, almost 50% of these cases, the arbitral tribunal was involved, which means that they have done a preliminary non-binding assessment. And we do see very often that, particularly in highly complicated and very complex cases that may be bifurcated, tri, or even quadricated, that parties do go into an amicable settlement and terminate their dispute early. But of course, we do have a whole bunch of number of cases that do run until the end of a final award. But this is a very nice indication that this preliminary assessment can be absolutely key for an early termination. And we are very well aware, and I am very well aware, that we are talking to common law tradition lawyers, that is absolutely no-go in an arbitration. But we would invite people to think out of the box. We do have, particularly from a German and civil law tradition, are very successful with these preliminary non-binding assessments by the arbitrators. And as said, this is only be done with the consent of all parties. So, and also with the background of maybe mediation, this might be easier for you to access. So we would like to invite people to think how that's going to be, to have that. But we are well aware of all problems, which means if you come to us a first time having such or facing such preliminary non-binding assessments, we can give you assurance, and we also have the means to comfort people from common law jurisdictions facing the first time with such preliminary assessments.
I think this provision actually would do really well even in expedited processes. If people in expedited arbitrations, if they incorporated this, it would work well there too. So thank you, Paulus, for explaining this through, so wonderfully. I am very well aware that we are running very short on time. So I'm going to come to the lighter part of the discussion and quickly ask each one of you all to tell me a must-visit place that you have discovered in the city of the headquarters city of your institution. Eliana, if I may ask you for London, which is that place that you have discovered, which you think that people should come and visit?
Not related to arbitration, am I right?
No, not related to arbitration.
Because otherwise it would be the IDRC.
No, not related to arbitration.
Well, I think it's a difficult choice to make. There are so many things to see in London.
Just give us one. Just give us one.
I would probably say King's Cross, because you have the canal, and you have the new, the old, the modern. So it's very nice and typical of London, a typical transformation of old building into a modern one, all the area.
Okay, and if you visit the King Cross station, then you get 9 3/4 and the Harry Potter station as well.
Right?
Elisabeth, can I ask you for Vienna?
Sure. I think what's special about Vienna is that even though for Austria it's a huge city, 2 million people, it has a lot of green and parks and water. I love the water. The river that flows through Vienna is the Danube. So I would say the Danube, especially that part that is called the Old Danube, where in summer you go there by metro and suddenly you feel like you're in vacation. There's sailing boats, beachside cafes and everything. You wouldn't think you're in the city. So I recommend that for the summer in particular.
And of course, the blue Danube would be playing behind the background.
Of course, the waltz.
Tejas, I know you're in Singapore, but I'm going to ask you for Paris.
Yeah, Paris has many spots, and as cliche as this sounds, for me, the best spot is the third floor men's washroom at the ICC headquarters, which has the best view of the Eiffel Tower, according to me. It's very close, it's unobstructed, and it fits right in the frame of the window, which is a black border, so it looks like a painting.
So basically, you have excluded Elisabeth, Eliana, and me from.
I am told that it's no longer the men's washroom. It's actually for men and women both now. So I don't know if I can say this, but if you're in Paris, do drop by. I think we'll definitely take you to the terrace, if not the washroom.
I'm sure that's the most unique tip anybody's ever given to anybody. Paulus, you are in Bonn. Can I ask you something about a place must visit in Bonn?
Well, I said Bonn was the former capital city of Germany, and it's also the birthplace, by the way, from Ludwig van Beethoven. So whenever it happens that you are in Bonn, which is not very likely in international arbitration, but if that happens, I think the hidden gem is actually our office building, which is a villa in the middle of the green, right beside a farm. And we have an enclosed park, and not because it is the DIS, but you can even have a look on our webpage. That is really a villa. All our guests arriving at our office, whenever they do, they always are stunned because of the peaceful environment. And I can even tell you mediations that have taken place in our office building, they have been all successful. We have a success rate of 100%. So it is a hidden gem, what you would never expect from a city like Bonn. So just visit us.
That 100% rate makes it a must visit. With this, I would like to thank all the panelists for joining in and talking about their cities and their institutions. But I also want to take a quick minute to thank MCIA for organizing the India ADR week, firstly, but also for doing this entire series of webinars where they're getting all of the institutions together, because it's a collaborative environment. We expect India to be, we keep saying it, but we genuinely hope that India is the hub of arbitration going forward. Indian parties arbitrate both in India and outside. And the more we collaborate and the more institutions we work with, it becomes second nature to us when we look at arbitration. And that's the whole reason for getting together and speaking about it. And MCIA has really, really understood the ethos that if you want arbitration to thrive with institutional arbitration, the idea is to collaborate. So thank you, MCAI, for doing this. Thank you, Neeti. Thank you, Charvi. We've had We look forward to the other webinars that are yet to come on 24th, 25th, and 27th. Thank you, everybody.
Thanks so much. Bye-bye.
Thank you so much.
Thank you for
Bye-bye.
the
Thank
audience for
you.
tuning.
Bye.